14 students in this class, and we have 10 who are now attending. So for the first couple of minutes, there'll be, the remaining students coming to join us, which is perfectly normal for this kind of class in the evenings. So most of you were here on the introductory class on Monday, so there's very little to go over with respect to what we discussed. So the slides are on Moodle for the introduction, which basically broke down the topics to be discussed. It broke down the grading, so how it's divided between participation, breakout questions, the group presentations, the final exam and or final paper, and a film study. So that makes up the total grades that we're going to be looking at over the course of the next essentially 5.5 weeks. The only other thing that I wanted to make sure that everybody was on side with was the issue of the textbook. So this is the textbook in hardcover. I'm kind of old fashioned because I'm kind of old. So I tend to rely upon hard copies of textbooks, but I'm sure most of you are probably every bit as comfortable having the online access. So I sent everybody yesterday, I believe it was, further information from Emon Publishing with respect to how to access the textbook online and or order it if you want a hard copy. And I can tell you that the bookstore at the university is also getting hard copies of the textbook in. So hopefully everybody, if you don't have it by tonight, you should have it by next class on Monday, which is kind of important to have it because we're getting into the real nuts and bolts of the course. All right, so as I said on Monday, that class and tonight are very much introductory classes. So tonight we're talking about Canadian law. So I'm going to give you a bit of a background on Canadian law, where it comes from, how it's evolved, and how it is applied today in Canada. All right, with respect to the operation of the classes themselves. So again, as I indicated on Monday, usually we have a video that I post before a class that we will discuss at the beginning of the next class, and I'll post breakout questions before class that we will discuss in the next class after my lectures. None of that applies for this week, right? So there wasn't any video posted or breakout questions, but I will be posting a video tomorrow or Friday for the purposes of Monday's class, and 3 or 4 breakout questions. I haven't decided how many groups we're going to have, but based on 14 students, it'll probably be 3 groups. But I'll decide that when we get to next class. All right, any questions about this so far? Okay, so starting tonight, I'm going to record participation. So as I indicated from last day, every time you just simply show up, you're going to get an 8 out of 10 for simply being here. And then if you have a question or you answer, something that I seek to get an answer for, then, you'll get a 9 and or 10. Okay, so it's a pretty easy way for you to get a good mark on that part of the course. Okay, I should also tell you right at the outset that these lectures are, and the whole thing during the course of the evening is recorded on Zoom. So I will, after each class, post the class discussions and lectures for the previous class. That's there for you to go back and refer to. So for instance, that would be important for you if you're doing the final exam, because the final exam will not only include the readings, but it will also include contents in the PowerPoints in the lectures that I present. So you can always go back and review them, in addition to obviously, of course, the PowerPoint that is going to be on Moodle for each class, which I'll post prior to each class so that you can have it, so you can take a look at it and follow it with me as we go through the lecture themselves. Okay, so that's pretty much again, the recap for Monday and tonight's overview. So I'm going to share the screen with you now, which will be the lecture, the PowerPoints for tonight, dealing with Canadian law. Okay, so, and again, I'm doing this because for 2 reasons. Firstly, as we discussed, and as I said out in the course outline, sports law isn't a discrete, unique kind of law on its own. It's not like criminal law or tort law or contract law. It's not one of those kinds of very substantive areas of the law. it is the function of the application of a number of substantive areas of law. So for instance, next class, we're dealing with the law of negligence, right? And I'll certainly be, giving you at the beginning of that class a lot of material on negligence so that you'll be able to apply it to sports law. There is going to be a class that deals with doping, and that may lead into things dealing with the criminal law. There's going to be classes dealing with intellectual property, which again is a discrete area of the law, but it's very unique for sports law. And you guys would all know this because there are any number of sports figures that that associate themselves with very big, like Michael Jordan, right, has used intellectual property law to the ultimate. There's a number of sports figures who do that. So you need to have the substantive area of law, the background for it, in order to apply it specifically to the area of sports law. All right, so that's what we're going to talk about throughout the course, but in very broad terms tonight, I'm going to give you a background on Canadian law. Again, I haven't taught a first or second year introductory to law course for those of you who are jury students. Some of you are poly, but most of you are jury. I haven't taught that in the last few years, so I really don't know what you've been taught in this regard. So I'm just going to, in a very broad brush kind of way, going to teach you tonight what is particularly relevant regarding Canadian law, how it has evolved, and what it is today. All right, so we're going to talk about the roots and sources of the law. We're going to go through the court structure. So if somebody is issuing an action that's relevant to a particular wrong that has happened to them, and again, we'll talk about these in more detail throughout the semester, but I'm going to give you the court structure, primarily in Ontario, obviously, as to how someone would bring a claim if they think they've been wronged. All right, and then we'll touch upon jurisdiction for sports at the end. Although, again, going forward, more and more of these lectures will deal specifically with sports and not just with the background leading up to whatever issues are particular to sports law. So we're going to look at what is the law, basically, and the histories and sources of the law. So the first video we're going to watch is basically what is the difference between ethics, morality, and the law. So this is about 5 minutes in length.
The world around us is a smorgasbord of beliefs, claims, rules, and norms about how we should live and behave. It's important to tease apart these factors so we can put them in their proper place. Otherwise, it can be hard to know what to do, especially when some of these requirements contradict others. Let's talk about 3 different categories of demands on how we should live: ethics, morality, and law. Laws are formal rules that govern how we behave as members of a society. They specify what we must do, and more frequently, what we must not do. They're upheld and applied by the state and the court system, and their role is to create a basic, enforceable standard of behaviour. But the law has a much narrower focus than either morality or ethics. Laws can be just or unjust and are subject to ethical assessment. Plus, there are some matters about which the law will be silent, but where morality and ethics have a lot to say. For example, the law is of no use if you're trying to decide whether to speak up when you hear a friend make a racist joke. But ideas about what's good and right will still guide our judgment here. Morality refers to an informal framework of values, principles, beliefs, customs, and ways of living. Moralities aren't usually enforced by the state, but there are often social pressures to conform to moral norms. Some people consider themselves to be so strongly bound by certain moral codes that even to question the moral system would be wrong. Some examples of moralities include Christianity, Stoicism, and Buddhism. Each of these provides a set of answers to basic ethical questions like, how should I live and what should I do? Many people inherit their morality from their family, community, or culture. It's rare for someone to shop around for the morality that most closely fits their personal beliefs. Usually, the process of moral formation is unconscious. What sets morality apart from ethics is that you can apply a morality as a matter of habit without having to think. You can simply obey or follow instructions from those who claim moral authority within a particular tradition. And for some people, this is enough. Maybe a world of habitually virtuous individuals is better than one where people are habitually vicious. Plus, having a coherent, consistent account of how to live can be a source of comfort, especially in a complex and uncertain world. But there is also a risk in living what the Greek philosopher Socrates called an unexamined life. If we just accept a ready-made answer to the question of how we should live, we might live our whole lives under a moral system which, if we'd thought about it, we would have rejected in part or in full. This is where ethics comes in. Ethics is a branch of philosophy that aims to answer the basic question, what should I do? It's a process of reflection in which people's decisions are shaped by their values, principles, and purpose rather than unthinking habits or social conventions. Our values, principles, and purpose are what give us a sense of what's good, right, and meaningful in our lives. They serve as a reference point for all the possible courses of action we could choose. On this definition, an ethical decision is one based on conscious reflection and which gives effect to our values, principles, and purpose in pursuit of a proper goal. It can be tempting to see law, morality, and ethics as more or less the same. We might think that so long as we're fulfilling our legal or moral obligations, we can consider ourselves ethical. In reality, there is more to ethics than morality and law. Ethics requires us to think about issues the law can't or doesn't address. It puts moral systems under the microscope to see if they hold up. In an ideal world, our ethical beliefs shape the kinds of laws and moral systems a society develops. When our conscious, reflective, ethical views on what's good and right change, we ought to change the laws to reflect them. And likewise, our moralities should evolve in response to insights generated from ethical reflection. But we can only do this if we have a toolkit that keeps open questions to do with what is good and right. And that toolkit, that's ethics.
Okay. All right, so now we're going to go right, that's a very broad kind of thing for you to look at. So now we're going to go back to actual reality with respect to a great degree, the establishment of what law became in England in the year 1215 with the Magna Carta. And again, if any of you, or hopefully most of you, have taken introductory law classes in jury or law and justice, you'll be very familiar with the Magna Carta. Right, the Magna Carta was probably the most significant document in the history of the English-speaking world for the establishment of liberty and freedom. It had its 800th anniversary in 2015, and remember, obviously back in 1215 there wasn't printing presses, so they were hand done by monks for the most part, and I believe there were 8 or 9 original Magna Cartas actually transcribed. And what they did is they put them on display and they toured the world. So there was a period of time in 2015 where, and I'm not even sure where it was in Canada, but it did tour Canada. So, people who were, that interested in the Magna Carta, so they're law geeks for the most part, would in fact, go and see wherever it was and actually take a view of it in person, which is pretty cool. Again, if you're a law geek, which obviously I am, because I'm here teaching you. So anyway, the Magna Carta is incredibly important. It was the first time essentially that you had rules and laws that were put in place for the people, right? Not just the king. So up until that point, the king was supreme. Everything the king did had to be followed, had to be adhered to, because that was the nature of the royal prerogative. All right. But what happened in 1215 was that King John, who was looking to raise money for going to war, kings, or it's all they ever did really back in those days, was go to war. And they were all in England was always at war with France. That's just the nature of the geopolitical atmosphere in the time. So he wanted to raise money, and it's the feudal system. And I'm not even, I could spend a whole class on the feudal system, but he was entitled to go to his nobles in this pyramid of power and ask them for money to help him go to war, and B, for knights who were under the control of the nobles to fight on his behalf. And for the first time in English history, right, the nobles pushed back. Now, before I go any further, why are we talking about what happened in England? Anybody? Okay, so we have a couple of hands, so let's see here. So Abigail was first. So Abigail?
Because we follow common law tradition in Ontario, which came from England.
Not just Ontario, but Canada for the most part. Keel?
Mostly because we still have quite strong ties with the British monarchy system as well, since Queen Elizabeth is still technically Queen.
Yes, Queen Elizabeth, in fact, II is the Queen of Canada. Okay, good stuff. So you guys get it, that in fact our laws came from England. As a matter of fact, when we confederated in 1867, part of the British North America Act of that year adopted the laws of England. We already had, prior to that, we were a British colony where obviously the English law was already in place before we became an independent country, or a dominion, not quite totally independent, but a dominion. So when we did become a dominion, which to a great degree gave us some independence, we still absorbed and inherited the English law, which was the English common law. We're going to talk about common law a lot more in a few minutes. All right. So anyway, what happened was 1215, King John wanted he wanted to tax his nobles to, in fact, again continue to go to war against France. They pushed back and said, "Look, we're not going to support you in doing this unless you give us concessions." And the concessions ended up being the Magna Carta. Now, and while the Magna Carta, if you read it very carefully, really was only drawn to protect the interests of the nobles, because the nobles really didn't care about the common person, right? They really didn't. I mean, that was a lot. The serfs were a long way down the feudal ladder of authority. But having said that, the Magna Carta was still seen, even though it didn't necessarily deal with the people themselves, it was over the course of time adopted as being a public document of liberty and freedom, right? So in fact, even though that wasn't the intent, that was the end result, is that it ended up being the greatest rights document in the English-speaking world. All right, so King John was the successor to the throne of King Richard the Lionhearted, who went off to crusades, most commonly portrayed by Sean Connery in any movies you would see in that regard. And then after him came King Henry II, who succeeded Richard I. And he really was the monarch most instrumental in the creation of the common law. All right, so the video we're going to watch, this is done about 10 years ago by a very famous professor at the University of London, who she's a dame, so that's the equivalent of being knighted. And I'm going to have you watch this. This is about 20 minutes long, so it's on the long side, but I want you all to pay attention to it because it's incredibly, I can't emphasize this enough, it's incredibly important for you as law and justice students, or at least in a jury course, that you understand the common law, because the common law is, the application of the law as it applies to Canada. And again, we'll talk about that in more detail, but her lecture is a really good place to get a very good overview of the common law.
When we say the common law, what do we mean? We're talking about the laws of the land, the laws that we have to comply with which are essentially created, developed, and applied by judges sitting in court deciding on disputes in individual cases, deciding on disputes in the civil justice system or on criminal disputes when they're dealing with criminal cases. So it's the law of the land created essentially by the judiciary. The broad common law comprises laws, legal principles articulated by judges in individual cases in court. So the common law is sometimes referred to as case law because it emanates from individual cases. The common law develops by judges following the decisions of other judges who have decided similar cases previously. And when judges follow the decision, follow the reasoning, follow the legal principles applied by judges in previous cases, what they are doing is following the doctrine of precedent, the concept of precedent. So a judge, when he decides a case today, looks back at how judges decided that a similar kind of case in the past, what principles did he apply, what reasoning did he apply, and the judge will follow that reasoning today. That's the operation of the doctrine of precedent. Judicial decisions that have already been made in similar cases are documented in collections of case law known as yearbooks and reports. And the photograph that I showed you at the beginning is a section of the law reports. So these decisions are collected in the law reports, they create precedents, and the precedents are applied to new cases that come before the courts. We're going to look at how that's done in detail in one of the later lectures. But for the moment, what we're going to do is focus on some of the history of the development of the common law. Coming back to William Blackstone, he gave us a rather good definition of the common law. He says the common law is to be found in the records of our several courts of justice, in books of reports and judicial decisions, in treatises of learned sages of the profession, prescribed and handed down to us from the times of ancient antiquity. They are the laws which gave rise and origin to that collection of maxims and customs which is now known by the name of common law. Now, William Blackstone was the first scholar to attempt to bring together all of the common law of England, and he did this in the 18th century. He gave a series of lectures in Oxford, and the lectures were published as commentaries on the laws of England. They were produced in 4 volumes, so he must have been incredibly busy, between 1765 and 1769. And what he did was to attempt to systematize all of the common law decisions that had been made by judges over many, many years. It was the first attempt, William Blackstone's commentaries was the first attempt to state the entire corpus of the common law. They're still seen as probably the most comprehensive summary of the body of English law ever compiled by a single author. They are said to be clear, sophisticated, and they remain highly regarded. In fact, it's said that Abraham Lincoln, when he was studying to be a lawyer, used to read Blackstone by candlelight. And in fact, you might not realize it, but Blackstone is responsible for many phrases that have become part of common usage, and I'm sure that people don't realize where it comes from. So, for example, the phrase, "It is better that 10 guilty persons escape than one innocent person should suffer," was actually first said by Sir William Blackstone. And again, we'll look at that idea that it's more important that innocent people should not be wrongly convicted. We'll look at that idea later on when we look at the values of the criminal justice system in one of the later lectures. So, the development of the common law. How did the common law develop? Now, I'm going to take you back in time because a reasonable starting point is actually in 1066 with William the Conqueror. I don't want to give the impression that there was no law prior to 1066 and prior to William the Conqueror invading Britain, because there was a complex of local laws. But William the Conqueror was the first king to have the idea of trying to produce a unified system of law throughout England and Wales. So William the Conqueror invaded from France. He invaded England from France in 1066. As I say, there was already a functioning system of law and of local justice in the counties, or what are known as shires. Different parts of England were actually governed by different systems of law, and the systems of law often derive from various people who had invaded England at one time or another. So, for example, there was Dane law in the north of the country, Mercian law around the middle of the country, and Wessex law in the west and southwest. But there was no unitary national legal system. The English legal system, insofar as it existed, involved a mass of oral, customary rules that varied from region to region. Each county or shire had its own local court, and these local courts dispensed their own justice in accordance with local customs that again varied from community to community. So you had bits of law all around the country, but very different laws being enforced in different ways. And it's been said that sometimes the law was enforced in a rather arbitrary fashion by local lords and landowners under the feudal system. These local courts that existed around the 11th century were not the kinds of things that we would recognise as courts today. For example, courts often consisted of informal public assemblies that weighed conflicting claims in a case, and if they couldn't reach a decision, they might ask the accused to show their guilt or innocence by carrying a red-hot iron or snatching a stone from a cauldron of boiling water, or some other test of the veracity of their claim, of the truth. This was known as trial by ordeal. Now, there are some debates about the extent to which these trial by ordeals actually were carried out, but it is quite clear, looking through the material at the time, that it was a recognised way of seeking to establish the truth of a person's guilt or innocence. The idea was, if you got somebody to pick up a red-hot iron, the defendant would pick up this red-hot iron. If the burn that would naturally occur as a result of picking up a red-hot iron, if the wound healed within a few days, the man would be set free. He would deem to be innocent. If the wound didn't heal, he'd then be executed. So it sounds like bad luck to have to pick up a red-hot iron. The wound doesn't heal, so that'll be very sore, and then they hang you. But the idea of the trial by ordeal was that if a person was innocent, that God would intervene and God would perform a miracle. So the person who had picked up the red-hot iron would have their hand heal in a matter of days because God had intervened and they would go free. Certainly a fairly brutal way of establishing guilt or innocence. It seems that actually at the time there were more acquittals than convictions, so perhaps it wasn't as brutal as it sounds, and the business of trial by ordeal was actually eventually stopped, or it was condemned by the church in the 13th century. But there is no doubt that it was a feature of local justice. So we've got this system of local courts with local customs and trials by ordeal. William the Conqueror was interested in establishing his power and in establishing order in a relatively unruly kingdom. He laid the foundations of the legal system. He understood that in order to exercise real power over citizens, he needed a central system of justice over which he, as king, had power, and he had laws that would be obeyed by the citizens. So how did he do this? He created what was called the Curia Regis, the King's Court. This was a court of law, but it was also a royal household that comprised the king and some of his most trusted advisors. And the Curia Regis would be an advisory body for the king, but also it would be a place where people would bring their disputes to have them decided by the king and his advisors, or essentially for the king to resolve. Now at this time, England, or the kingdom, was not particularly heavily populated. On the whole, people couldn't read and write, and travel around the country was difficult. Although the Romans had built lots of roads in England and Wales, they hadn't actually been fixed for the 800 years since they'd been left. So it was quite difficult to move around the country. So in order for kings to maintain their authority over the entire kingdom, kings were in the habit of travelling around the country, taking their court and courtiers with them. So they would process to different parts of the country. And William did the same thing. He would travel around with his Curia Regis, his king's court, going around the country to different areas. And as he travelled around the country, people would come to him, citizens would come to him and bring their grievances, their complaints, their accusations against other people. And the king and his advisors would give judgment. They would give a ruling on the dispute. The king would literally sit on a bench and hear cases in his own court. And this is why one of the most important courts at the time was known as the Court of King's Bench. So the king would sit on his bench, have his advisors around him, and people would come to bring their grievances to him. And we can see this activity, the activity of the king and his advisors going around the country and him giving rulings on disputes and grievances around the country. We see this activity as the beginnings of the common law system, the beginning of a centralized or unified system of laws, because you have a consistent approach by the king and his advisors. Another thing that William did was to integrate the idea of juries into English justice. So under the jury system, royal ministers or justices would go out into the country to try and determine the manorial estates for the purpose of taxation, because they had taxation in those days. And what the minister would do in order to establish the value of these estates so that the king could decide how much he was going to charge people in tax, the minister would call 12 free men, so people who were not serfs, 12 free men together, and ask them to testify under oath about the value of each estate. And this assembly of free men was called the jury. Eventually, the jury became a body responsible for finding facts in both civil and criminal cases. And I'm going to come back to the use of juries in criminal cases, which was developed by Henry II subsequently. So we have the idea, at this point, we've reached a system where William the Conqueror, trying to establish his power over the country, he travels around the country with his Curia Regis, listening to grievances and disputes and giving rulings on it. So as I said, the beginnings, the essential beginnings of the common law system. Well, after William left the throne, things went rather downhill in terms of social order. This gives you the names of some of the various kings that took over after William I. There was a fair bit of fighting going on and disruption in the country, and in particular during the reign of Stephen, who seemed to fight with absolutely everybody, things went into a state of near chaos. In fact, it was said at the time that things, or it has been said, that things were so bad under King Stephen that it used to be said that it was a time when God and all his angels slept. It was such a dreadful time of chaos. And the next important step in the development of the common law system was after Stephen and when Henry II came onto the throne. Henry II came to the throne in 1154. He's one of what's known as the Angevin kings. The kings known as Angevin because of their connection with Anjou in France. So Henry II, Richard I, and John were known as Angevin kings. Henry II took the throne, as I said, after a period of considerable disruption. He wanted to regain stability. He wanted to reform land law because there had been a lot of thieving of lands during the time that Stephen was on the throne. And he wanted to deal with rampant crime. I said that he came to the throne after a period of great turbulence. And Henry II played a significant role in the development of the legal system. He, like William the Conqueror, was focused on creating a single system of justice for the whole country that would be under the control of the king. So he was also interested in power as well as order. And it was under Henry II that for the first time judges were sent out on circuits. The idea that judges from London, from Westminster, would travel around the country. At that time, the time of Henry II, there were only 18 judges in the whole country. That's quite remarkable when we think of the number of judges we've got nowadays, that they managed with 18. Smaller population, obviously. 18 judges in the whole country. Henry ordered 5 of those judges to stay in London and take over the cases that he might have decided himself. And these 5 judges that stayed in London constituted the King's Bench of Judges who sat in Westminster Hall. In 1166, Henry issued a declaration of assize at Clarendon. An assize was an early form of King's Council, or a sitting of court. And in this declaration of 1166, Henry said that remaining judges would be sent out to travel to different parts of the country. So the idea of judges going out to different parts of the country, dispensing the justice of Westminster, dispensing the King's justice that had been decided in Westminster. So when the judges travelled, they had to apply the laws that had been made in Westminster. And in this way, gradually, local law, local justice, was replaced by new national laws. Laws that were common to all, the common law. So travelling judges formed a nucleus of judges with national jurisdiction. They didn't have local roots, and one of the advantages of having judges travelling around the country was because they didn't have any particular stake in a local area, it was thought that they were less likely to be subject to influence and even possibly corruption. So the idea that you have judges that go from Westminster, they go out to a local area, they don't know the people in the local area, and they dispense justice from London, was thought to be a very good way of establishing a unified legal system, and one that was relatively free or protected from corruption. In time, the decisions of these judges started to be written down. Originally it was all oral, gradually the decisions of the judges were written down, and as the decisions of these courts came to be recorded and published, so the practice developed of past precedents being applied, being cited in arguments in court, and being applied by later cases, in later cases. And through this system, if you think about it, judges coming from Westminster, going out to local areas, hearing cases, deciding cases, and beginning to write down the decisions in those cases and apply them in later cases, what you get is the gradual spread of the common law from London, from the King's Bench in Westminster, out to the rest of the country. And this is how we have a sense that the common law spreads to the whole of the country, and you get the development of a unified common law. The first system of law reporting, the first examples of law reporting are from the 13th century, dated from around 1272, in the early years of King Edward I. And the earliest law reports are known as the yearbooks. These are the principal source materials, they were the principal source materials for the development of legal doctrines, concepts, and methods. And during the period when the law was being reported in the yearbooks, we have a period it is a period where the common law developed into the recognizable form that we have now. These original reports were actually written in either French or Latin. So gradually we've got the spread of the common law through the country. As royal courts became established, so the importance of local laws and customs began to fade away. The content of most of the law at this time was directed largely at preventing bloodshed by recognising rights to property, personal freedom, and punishing people who committed violent acts. So that is a rather basic introduction to the development of the common law system and the common law courts. In the next section, we're going to look at some of the difficulties of the common law courts that gave rise to the development of equity. But before we move on to that, I want to reflect a little bit on some of the things that I've said and the significance of some of the things I've been talking about. So first of all, I think it's interesting to note that the assizes system, the system of judges going out around the country and sitting in different parts of the country, established by Henry II actually lasted pretty much until 1971. Now that itself, I think, is quite an extraordinary fact. Something established in the 13th century continues until 1971. And if you think about it, we may not think about it, I'll tell you about it. We have a current system now where High Court judges from the Queen's Bench Division still travel around the country to hear the most serious criminal offences and to deal with serious civil matters. Judges who sit in the High Court of Justice in London still spend part of their time each year serving in courts outside of London. That is the continuing circuit system, which we see is a development from Henry II's idea in the 13th century. Another of Henry II's innovations was the further development of the jury. I said it was established initially under William the Conqueror, but actually Henry II used the jury for dealing with criminal cases. One of the things he did was to use people from certain localities, to bring them together, 12 people, 12 good and lawful men from townships or villages, bring them together periodically for the purpose of telling the king whether or not they knew or suspected that people had committed things like robbery, murder, theft, arson and forgery. So the idea of bringing people together to identify members of the community who were thought to have committed these crimes. And that use of the jury is the precursor to the use of the grand jury, which is used in America today, and it also forms the basis of our two-stage system in the criminal justice system in England and Wales, where a person is brought initially on indictment and then is sent for trial. We'll look at the development of the modern jury later on, but again, it's interesting to reflect that actually the roots of the jury go back to William the Conqueror, and to the criminal jury go back to Henry II. So some further reflections. Until the 12th century, the vendetta, blood feuds, was actually an integral part of English life. And what we see is that the ending of blood feuds in England roughly coincided with the establishment of the King's Courts in the 12th century. The courts didn't just punish criminals, they also provided a peaceful means for resolving disputes over land and other property. So the courts, even at that time, were offering a service to the public. Instead of people solving their disputes by resort to violence, what was happening is that they were being encouraged to bring their disputes and grievances to a public forum, to the court, to the king, to the king's justices, to be offered a remedy, for a decision to be made on right and wrong, and for a remedy to be offered. So what we see is the idea of encouraging people not to take the law into their own hands and resolve their disputes by resort to violence, but actually to bring them to public forums for the peaceful resolution of those disputes so that they can receive a remedy. So in the resolution of disputes over land, contracts, debts, as well as dealing with criminal offences, the courts were supporting social order and the tranquility of the state. And that is just as true today as it was in the time of William the Conqueror and Henry II. The courts underpin social order. As I said, they're not just about punishing criminal acts, they're also about peacefully resolving disputes. They support economic activity, they support social harmony, and it was a struggle at the time to get people to bring their cases to these public courts, and it's something that we have to be careful to protect in modern times. Another reflection, or a final reflection, is the extent to which the English common law has influenced the development of legal systems around the world. This is a map which shows the spread of common law to other jurisdictions in the world. So the English common law tradition was transported around the world to places that had been colonized by the British. So you can see that there are common law systems in Australia, the USA, Canada and New Zealand, all of those have connections with England. And other countries that have also had connections with England have a mixed system, but also retain some elements of the common law. So, for example, parts of Africa, India, and parts of the Far East. So we see that the influence of English common law, the values and principles of English common law, has been very great, not just in our own country, but in countries around the world. We're going to discuss some of the features of other legal systems later on, in particular civil law systems that are common in Europe, Africa, Asia, and South America.
All right, guys. So, I mean, that was 20, 25 minutes, but for some of you, it's nothing new because you would have already studied this in any number of jury courses before you get to this one. But for those of you who haven't had this knowledge before, this was a really, really excellent video to give you an overview of the common law as it developed in England. And I will tell you in more particularity how it was translated into Canadian law. All right, so the King's Bench, and the professor, she mentioned this a number of times, which was established by King Henry II, who basically sent his justices out into the country and had them return to London to render decisions on behalf of the king, and it was referred to as the King's Bench. And again, as a function of the British North America Act of 1867, when the English law was adopted into Canada as its national law, the common law, it also adopted the procedures set out in the King's Bench. And we still have that today. So all provinces and territories across the country all have a superior court of justice, originally known, as it turns out, as the Court of Queen's Bench. And so we still have that in Alberta, Manitoba, New Brunswick, Saskatchewan, Newfoundland, and Labrador. So the individual superior courts in each of those provinces is still the Court of Queen's Bench. We have differences now in Ontario. So Ontario, we no longer have, but we did at one point, had the Queen's Bench, but we now have what's called the Superior Court of Ontario. In British Columbia, we have the Supreme Court of British Columbia. It really doesn't matter what the name is. They are all exactly the same thing. They are the Superior Court of Justice, basically established in Canada as a function of English law. Any idea why it's called the Court of Queen's Bench and not King's Bench? Anybody? Okay, the answer. Oh, Kyle?
Because we have a queen right now instead of a king.
That's exactly right. And so, Queen Elizabeth II is on the throne, so we have a Court of Queen's Bench. Actually, when Canada was established in 1867, Queen Victoria was on the throne in England, so it would have been a Court of Queen's Bench even then, and it would have been the Court of Queen's Bench in England at the same time. Now, who, and I'm sure you guys know this, who succeeds Queen Elizabeth when she passes? She's now 95 years of age. So, sometime in the next 30 or 40 years, she's going to pass away. I mean, she comes from pretty good stock. It's not going to be that long, but she's going to live a few more years. Who succeeds Queen Elizabeth II? Anybody? Who's next in line to the English throne? Megan?
Prince Charles.
Exactly. All right. So Prince Charles will become king when his mother, Queen Elizabeth II, passes away. And so when that happens, the very moment that happens, because he basically becomes king the exact same moment his mother passes, he becomes king. And the courts of Queen's Bench in Canada, which are these provinces on the screen here, will immediately become the Court of King's Bench. And it'll be the Court of King's Bench as long as he's on the throne, and then he'll be succeeded by, I'm sure you know, is William, right? Who's his eldest son, and then after William, it's his son or daughter, because it doesn't have to be the son anymore. That only changed like 3 or 4 years ago, by the way. By the way, when Prince Charles takes the throne, he doesn't have to go by the name of King Charles, right? That's totally his choice. Matter of fact, it's actually quite unusual for princes in waiting or princesses in waiting to actually take their name when they become king. So, King Charles the Third, because there's been two previous Charles, it may be the case, but it's probably unlikely because the first two Charles were disasters as kings of England. So it's not a great name to go with. Elizabeth's father, by the way, was King George VI, but his name was, they called him Bertie. His name wasn't George. And his brother, who was King Edward VIII, who abdicated the throne in 1938 because he wanted to marry the twice divorced Wallis Simpson, a disaster for the royalty at the time. So his name was David, right? But he took the name King Edward VIII. So all I'm saying is when in the next 3 decades, when Queen Elizabeth passes, her son, won't necessarily be King Charles. It'll be any name he chooses, and we'll see what happens. It'll definitely happen in my lifetime, and we'll see what happens there. But having said that, that creates the Court of King's Bench again from the Court of Queen's Bench, which has been in place since 1952, when Queen Elizabeth succeeded to the throne when her father, King George VI, passed away. So, and as you would know, she's been on the throne. She's the longest living monarch in the world, and the longest living English queen, she just beat Queen Victoria a few years ago for the length of her reign. Anyway, having said all that, and again, it's the reason, and Kyle pointed this out earlier, the reason this is all important is because we are so intricately involved with England, and we still are, even though we're much more independent even than we were in 1867 when we became a dominion. The real independence of Canada took place in 1982 with what was called the repatriation of the Constitution, with the enactment of the Constitution Act of 1982, the Constitution Act of 1867, which replaced the BNA Act, and the Canada Act of 1982. So all those things took place and really, again, made us much more of an independent country, but we are still, we still have an English queen as the head of state. Okay, so having said that, notwithstanding the development of the common law, as was just explained to you in some length, and King Henry II, who came to the throne in 1154, there were still, and she touched upon this in the video, trials by ordeal that carried forward for centuries. And trial by ordeal are amazing kind of things that took place where the guilt or innocence of a person was determined by subjecting the accused to an unpleasant and usually almost fatal test. And the test was life or death, as in if they survived the trial by ordeal, they lived, and if they didn't survive the trial, they were put to death because they were seen as God, right, having found them to be unworthy of living. So here is a relatively short video on the trial by ordeal.
This is the second part of a 3-part series, and today we're talking about trial by ordeal. First part of the series was about trial by oath. Basically, in trial by oath, you'd just go into court and you'd say, I didn't do it. And that was good enough because it was believed that your oath, well, you wouldn't say something that wasn't true because you didn't want to risk eternal damnation. If you lied, well, you'd go to hell for lying. So it was good enough. Now, what I left out of that video was the fact that that was only reserved for people who were of good moral standing, good character. But for your average Joe the plumber, your normal ruffian, the guy who'd be hanging out at the pool hall today, well, you weren't so lucky. You had to go through something called trial by ordeal. And if you were considered an untrustworthy man or a scallywag, that's what you got to do. The theory was, with the trial by ordeal, was that if you were innocent, God would perform a miracle and he would save you. And if you weren't innocent, well, tough, you're going to face the consequences. There were different kinds of trial by ordeals. One of the types of trial by ordeal was trial by fire. And so when you've heard about, you're going to have a trial by fire, this is where it came from. In a trial by fire, and there was different kinds, but in a trial by fire, the accused would be made to hold a red-hot piece of iron. If it didn't burn his hand, well, that was a miracle, and he was not guilty. If it did burn his hand, well, he was guilty. Now, as a lawyer, of course, I represent a lot of people in hot water, and of course, I've been in hot water myself sometimes. But there were other versions of trial by water, not always hot water. One of the trials by water, which you may be familiar with from the Salem witch trials, was you would tie a person up and you would throw them in the water. The idea was that water is pure and water would reject anything that was unpure. In other words, it would float to the top. So if you were innocent, you would sink like a stone to the bottom. Of course, you would drown, but let's ignore little subtleties like that. You would drown if you were innocent. But if you were guilty, you'd float to the top. You could breathe. And so, if you floated, hang him. Not really a good result either way if you're the person who's thrown in the water, but that's how they did it at the time of Salem. Now, my personal favorite, of course, is trial by cake. A trial by cake was reserved for the hoi polloi, usually members of the clergy. And in trial by cake, you'd get to take your cake, and the idea was you'd go to the church and you would say, "Oh Lord, Lord, if I am guilty of this crime, may I choke on this piece of cake." And then you'd have to take a bite. So let's see. "Oh Lord, Lord, if I'm guilty, please let me choke on this cake." No. And apparently I am not guilty because I am not choking on the cake. At any rate, if you find yourself in a legal jam, yes, I know there's stuff in my nose. If you find yourself in a legal jam or in hot water and you want our help, just...
Okay, so you guys get the drift of that, and I'm showing this to you because these are the things. Oh, Shivani?
Oh, I was just asking that by right, if by using the trial by ordeal, by right, if anyone holds something so hot, is it by nature that it's gonna burn everyone's hand? How would they find justice from that?
It was actually a little more complicated than what the speaker said there. So what happened is, and it happened either with you holding a hot piece of iron or poker, or putting your arm into a pot of boiling oil. In both those cases, what would happen is that they would wrap your hand or your arm in bandages or gauze for 3 days. So it gave you a fighting chance, basically. So for 3 days, it'd be wrapped up, and at the end of 3 days, and this was always done by priests because God was the supreme judge of all these things, and they would take the bandages off. And if it had healed, right, as in it didn't blister and it wasn't still burned badly, then you're innocent. But if there were still blisters and boils and the flesh was burned black or what have you, then you were guilty. So that's how that worked in more detail than what he had to say there. Does that answer your question?
Yeah.
Okay. All right. Okay. And then the next thing I want to talk about before we move into the really modern context of laws in Canada is what's called the Royal Prerogative of Mercy. And the reason I wanted to tell you about this is because, again, as the professor from the University of London had to say, there are a number of things that were put in place by King Henry II, the establishment of the common law and what have you, that still prevail today, not only in England, but in Canada. And the Royal Prerogative of Mercy is one of those things. And what this is essentially is somebody who is convicted of a crime, right, has the option to beg for mercy or apply for mercy and have the state, the king back then, now the state, basically look at the application for mercy and decide if there should be a pardon, right? And pardons are, Trump did a lot of pardoning before he left office. Pardons are still certainly available in all common law jurisdictions, or a mitigation of sentence, which means obviously a lesser sentence than what you have been convicted and sentenced for related to your crime. And the reason I want to point this out is because the Royal Prerogative of Mercy, which has been in place for centuries and centuries, is still found today in Canada's Criminal Code. So section 748 sub 1 of the current Criminal Code of Canada, 2021 edition says this: Her Majesty may extend the royal mercy to a person who is sentenced to imprison under the authority of an act of parliament, the act of parliament almost always being the Criminal Code. Right? So what this basically says is that, you know, this centuries old option is still available. And it actually is used quite commonly these days for any number of purposes, mostly with respect to pardons, but it can also go to mitigations of sentences. So what I'm going to show you is a very famous request for mercy from William Wallace, requesting mercy from the first King Charles, Charles Longshanks, King Longshanks he was considered to be. This is from Braveheart. So this movie is almost 30 years old, so probably a lot of you haven't seen it. Shame on you. It's a great movie. But I'm going to show you, this is almost one of the very last scenes where William Wallace, who was, just very briefly, William Wallace was a freedom fighter for Scotland when when England was trying to overtake it and, you know, bring it within English rule, because Scotland was an independent country for a very long period of time. And as it turns out right now, and you may have seen this in the news, as a function of Brexit, right? You know, Scotland had a referendum in 2015, 2016, when Brexit went to the public, and the referendum said they would stay in the United Kingdom. But because of Brexit, you know, going forward, the Scottish people as a whole very much wanted to stay part of the European Union. And so now Sturgeon, Neil Sturgis, who's the leading politician in Scotland, now wants to have another referendum for Scotland to leave England. So this is something we're now talking again, you know, 700-800 years later. So this is Braveheart. This is the freedom scene. This is where the prerogative of mercy is at play.
It can all end right now. Peace. Bliss. Just say it. Cry out. Mercy. Just say it. Mercy.
Mercy, William. Mercy. Jesus, mercy.
The prisoner wishes to say a word.
All right, guys, I worked that into every course. Don't worry about it. It's just, I'm kidding. Okay, so eventually the trials by ordeal and tortures requiring mercy, they were all replaced, up across the board by the universal application of the common law for both criminal and civil cases, right? Now, it's important to remember in Canada, so we have the common law system across all provinces and territories. But when it comes to civil cases, these are cases for things like tort law, property law, contract law, administrative law, those kind of things that aren't essentially criminal in nature. Again, it's the common law across all provinces and territories, with the exception of Quebec. Okay, and again, this is a very historical kind of thing with respect to the French being in North America prior to 1761, when the British, or England and France, settled their differences, and France left North America, but it did leave jurisdictions that were highly French, and one of them was the province of Quebec. So it was agreed when England took over North America, therefore making it British North America, that the civil law system dealing with those things we talked about, property, torts, whatever, in the province of Quebec would be in accordance with what's called the Napoleonic Code, which obviously is the law in France, which is basically applicable now in Quebec. So that is the only difference between Quebec and all the other provinces and territories. Again, the civil law is different, but the criminal law in Quebec is the same as everywhere else. So it doesn't matter where you are in Canada and you commit a crime, you will be subject to the Criminal Code of Canada. As an aside, by the way, the United States is actually the converse of that. So the United States, in fact, has 50 criminal codes. So every state has its own criminal code independent of each other, right? There is a federal criminal code that deals with federal crimes, but for the most part, it's totally the converse of what we have in Canada with respect to criminal law. We also have statutes and regulations. These are in fact enactments that Parliament passes. If it's Canada, it's Parliament. If it's Ontario, it's the Legislative Assembly in Toronto. So the province of Ontario has its own legislature. Canada has its own parliamentary system. Each of these has the ability to make law as well, in addition to the common law. And often what happens is that judge-made law, which is the common law, often decisions are made that may well be at odds with the ruling political party at the time, and they decide that in fact they're going to pass a statute to change the law as it's been administered by judges, right? That's often the way it goes. We're not going to go into a lot of detail about that now, but I will tell you that as we go through the course, there will be a number of statutes that I'll refer to that deal specifically with items that are relevant to sports law. Okay, so let's talk about the courts, procedure and structure. So in fact, how the Canadian court system is established and how cases proceed through the courts, okay? So courts have a function. Their primary function is to adjudicate, right? To listen and make decisions with respect to disputes between individuals, corporations, or governments, right? And the government can be in a civil dispute, civil not Quebec, but civil being torts, property law. And likewise, courts are there when there's a dispute between the government and individuals or corporations, which is in fact the case in criminal disputes, all right? So the courts are the most formal method of conflict resolution that we have, right? It's also the most expensive and time-consuming process, and it's the one that very, very often really requires a lawyer to participate. But unfortunately, because of the cost these days, there's a lot of access to justice issues on people not being able to afford to have lawyers to have their matters adjudicated. So that's a whole different thing, but that's the reality. There are also alternate methods of dispute resolution, which have grown over the course of the last 25, 30 years that are really important to pay attention to because they're alternatives to court. So things like mediation and arbitration, those are very important ADR ways to in fact have disputes resolved without going to courts. Okay, the courts are open to the public because justice, and I'm sure you heard this saying before, must not only be done, but must be seen to be done. So virtually every court process that takes place, all the way from the smallest small claims court case in Sault Ste. Marie up to the Supreme Court of Canada, almost all of them are open to the public. And so you can go into any courtroom and walk in the back door and sit down in the gallery and watch the proceedings. And that again includes the Supreme Court of Canada. There are some exceptions to that, but they mostly relate to where their cases involve allegations of sexual abuse or assault, where the victims are to be identified. And in fact, the courts can close those proceedings or put publication bans in their place. So again, this is a courtroom. I don't know how many of you, if we were in an actual class, I'd ask you to put up your hands as to who's actually been in a courtroom, but I'll just point this out to you. So this is how courtrooms are set up. Again, they're almost identically set up, again, all the way from the small claims court to the Supreme Court of Canada, with differences that I'll point out. So at the very bottom of the picture, you see those little boxes. Well, those are chairs. So that's the gallery. So at the bottom of that schematic, you would come in the back of the courtroom and sit down in the gallery. And that's where the public goes. Right in front of the gallery, and you can see are two black lines with a space between them. And you see the right hand, this little tiny word that says bar. And that is the bar. So when you become a lawyer, you're called to the bar. And what that essentially means is that you're called to the bar, meaning you can move from the public gallery to the other side of the bar and participate in the proceedings. That's what calling to the bar actually means. All right, you have on the right-hand side, you have a jury box, right? And there's 12 seats there. So in a criminal case, there would be how many jurors? Anybody know? How many jurors do we have in a normal criminal case? It's the same number you see TVs and movies, anything to do with courtroom drama. How many jurors? Anybody? Shivani?
I'm not quite sure, but I think 12.
Excellent. Good for you. It is 12. All right. Now, in a civil matter, okay, civil matters, again, torts, property, what have you, you can also have juries. Right? You don't tend to think of juries in those kind of matters because you almost always just see them on TV dramas in criminal trials. Any idea how many jurors you'd have in a civil matter? It's not 12. Anybody? Shivani again?
I think it's 6
Good.
or 8.
Yeah, you're hot. You're hot tonight. Great, good stuff. 6, right? So you have 6 for civil matters, 12 for criminal matters. You have 2 tables there. One says the plaintiff's table and one says the defendant's table. All right, and that's in a civil matter. If it was a criminal matter, instead of plaintiffs, it would say Crown, the Crown prosecution's table, and the other table would still be the defendant's table. All right, the desk in the middle, the court clerk's table, that's the court clerk. He or she runs the show when there's a trial. So they keep track of, receiving all the exhibits, passing them up to the judge, right? Keeping track of everything, adjourning the proceedings, sending the jury out for various purposes. The court clerk is in charge of the process within that room. And then up above that, you see the judge's bench. Okay, now if you were looking at, this is an overhead kind of view, but if you're looking at this straight on, you would see the judge's bench, at the top of the room, but it would be elevated. It would be significantly elevated over everybody else. Why would that be? Anybody? Why would the person sitting in the front? Abigail?
I don't know for sure, but I was just guessing because they're the highest authority in the courtroom.
Perfect. That's exactly right. The whole purpose of a judge sitting up and on a dais, basically above everybody else, is everybody has to look up to him or her, right? Who basically who has the authority in the room, right? And that just elevates that, the optics of it elevates the actual authority. And you see there's a witness stand just to the right of the judge's bench. And you can see that the witness stand is right next to the judge, right? So this is the last question I have for the courtroom. Why do you think that is? Why would you think the witness stand is so close to the judge? Kyle?
Is it so potentially the judge could see any cues of lying or perjury with a witness?
Yeah, that's the purpose, right? The purpose is the judge is within arm's length of the witness, so that they can be there to test their credibility, to see if they're twitching when they talk or whatever. If there's a tick, who knows, right? But that's the kind of reason that it's there. Okay, and so again, this is the exact template for every court in the country. Small claims court, would be exactly like this, except you don't have a jury in small claims court, okay? And if you go up to, for instance, the Ontario Court of Appeal, the bench would be large enough to hold up to 5 judges, but it's usually 3 who hear appeals. And if you go to the Supreme Court of Canada, there are 9 justices who sit up there. So the judges' bench is just that much bigger, but it's exactly the same template for a courtroom. Okay, so that's how courts are organized, right? Courts are presided over by judges, and these are what judges do. They follow the rules of procedure to ensure there's a fair hearing. Obviously, that's important. They interpret the statutes and the common law and equity. We're not going to talk about equity, but that's an offshoot of the common law. So the judge's primary purpose, to a great degree, is to interpret the law. So, for instance, in a criminal case, after the jury has heard the evidence, the judge will basically, based on the findings that the jury makes, will apply the law to that evidence and tell the jury how to make a ruling, basically, or how to make a finding based on the law. And lastly, but probably most importantly, they will determine the extent of the protections afforded by the Charter, which has been in place since 1982. So, and we'll talk about that in some more detail, but the Charter is obviously incredibly important in Canada. Where there is no jury, and there doesn't have to be a jury in all cases, the judge determines the facts and then rules on the law. Where there is a jury, the jury determines the facts and the judge rules on the law. Okay, so the judge always does the law, but the purpose of a jury is to make the findings of fact. So that's why juries in criminal matters are actually the ones who decide whether an accused is actually guilty or not guilty. That's a finding of fact, okay? The standard of proof is important. That standard of proof is the proof that whoever is bringing the allegation, has to prove in order to make out their case. So in a criminal prosecution, right, the judge can only convict if the Crown, being the Crown Counsel, which is going to be the state. So almost all criminal prosecutions in Ontario are brought by the Attorney General of Ontario, even though the criminal code is federal, right? The Crown has to prove their case, what's called beyond a reasonable doubt. I'm sure that's an expression you're all familiar with, all right? And if you think about it in linear terms, right? On a scale of 1 or 0 to 100, beyond a reasonable doubt is like just past 90. Just think about it. That's how sure the evidence has to be to prove something beyond a reasonable doubt. 9/10 of the way to an absolute positive outcome. Okay. In a civil matter, again, torts, property law, what have you, the judge will rule in favor of a party. Now, in this case, it's not the Crown, bringing a charge against somebody. It's a plaintiff, and we'll talk a lot about this during the course because we're dealing mostly with civil matters. It's a plaintiff who sues a defendant, right? And in that case, the burden of proof is basically on a balance of probabilities, which again, in that linear scale is, just past 50, not 90, but 50. So it's more likely than not that the evidence the plaintiff gives is true. That's the standard in a civil case. Okay. A court itself can either sit as a trial court or a court of appeal. So, the vast majority of courts sit as trial courts, right? It's very, very few that actually are heard on appeal. So that's the difference there. So what the trial court does is it hears evidence, it receives the testimony of witnesses, and hears the arguments of the parties, right? And that applies both to criminal and civil matters. A court of appeal, right, hears argument from the parties when one of them believes that the trial court has made a mistake. And obviously that just makes sense, right? I mean, if you go to trial and you don't like the outcome of trial, whether it was judge and jury or just a judge, right, then you're going to appeal it because you're not happy with the outcome. But in order to proceed with an appeal, the mistake that you're alleging to be made has to be either one, a mistake of law, or what's called a mistake of mixed law and fact, which still requires a mistake of law. And that means that the judge, and again, the judge is the one who's responsible for interpreting the law, has to make a mistake. And that doesn't happen that often. I mean, this is their job to get the law right, right? So appeals, there's very few appeals and very few appeals are successful, right? Appeals won't be heard when it's alleged as a mistake on the facts alone. So it won't be heard basically when the jury, for instance, makes a finding and the finding is only based on fact and has no law attached to it. Okay, so procedure before courts in private law. So private law matters are again are civil law matters, torts and contracts, whatever. Private law is like just another term for civil law, but not to be confused with the civil law of Quebec. And I apologize for those terms, crossing over, but they do. All right. So in private law, when a dispute arises between two parties over what's called a private wrong, breach of contract, tort, breach of trust, or negligence, right, the first thing that happens is that somebody has to start a legal process. And they start the process by what's called either a statement of claim or a notice of application. Both of those are called originating processes, right? So you go to court. Now in small claims court, you can do it online totally without ever having to go. That's a relatively recent, phenomenon. But in the Superior Court, again, Superior Court of Ontario, Queen's Bench of Manitoba, all those kind of things, you still pretty much have to go to a court office to file your statement of claim, right? And here's what it'll do. It will name who the parties are. And that's obviously important. If you're suing somebody, you want to make sure that you're suing all the people who you think are at fault for committing a wrong against you. It describes the nature of the claim. What are you suing for? Is it a contract? Is it a tort? Is it negligence? Those kind of things. You set out what the relief is being sought, which is, in civil or private matters, it's almost always damages. It can be injunctions or other small or mandamuses, those kind of things, those particular kind of prerogative writs, but mostly it's damages, okay? So I'm seeking $2 million in damages. So that's the relief sought, basically. And then the originating process, most often the statement of claim, will tell the defendant once they're served that they have to dispute the matter, in order to properly defend it, right? An originating process has to be served personally on the defendant. It's the only document in our system that requires that. So once you go to court and you issue a statement of claim, and the court will put a seal on it saying this is sealed as a document now in the court records, you actually have to take it and put it into the hands of the person you're suing. All right, so that's really important, right? And the reason for that is because it's a recognition that the defendant knows they're being sued. And that's incredibly important because otherwise, if they don't respond, there's consequences. So once the defendant is served, then there's a period of time for them to respond by filing their own documents with the court indicating that they intend to dispute the claim. The timeframes are pretty strict. If you're a plaintiff and you're suing somebody in Ontario, the defendant only has 20 days after they're physically served, right? You're going to be served either by the plaintiff themselves, which is kind of unusual. Mostly a process server is hired to serve somebody because, who wants to get punched in the nose when they serve somebody right? So anyway, so once they're served in Ontario, you have 20 days to say to the court, we're disputing this claim. If you're Ontario and you serve somebody in Manitoba or New Brunswick, they have 40 days to respond. And if you sue somebody in Michigan, even if it's just across the bridge, they have 60 days to respond. Okay, so after the defendant basically has said, I'm going to defend this, then what they have to do is they have to prepare what's called a statement of defense. So the statement of defense is a mirror image of the statement of claim. So what it does, it specifically responds to each allegation in the claim. So the statement of claim is going to say, you did this wrong for these reasons. This is why I'm suing you for this amount of money. So the statement of defense is going to basically say, I did not do what you're saying is wrong, or I did not do it, or even if I did do it, it's not worth this amount of money. So there's variations on what the defense does, right? And the statement, and along with that, there's going to be a statement of facts by the defendant setting out why the claim should not proceed, right? If the defendant thinks that he or she has a complaint against the plaintiff, as in they're sued and they go, hell no, I should be suing them, right? Then what they do is they file what's called a counterclaim, which basically is, not only do I dispute that you're suing me, I think that you owe me money and I'm going to sue you. And that's the counterclaim. So now you have a statement of claim, a statement of defense, and a counterclaim. Okay. Those are called the pleadings, right? So after the pleadings are done, then you move to what's called discovery, right? And discovery is exactly what it sounds like. It's a process where each party discovers how strong the case is of the other party, all right? So once the pleadings are completed and there's initial motions that are dealt with respect to the place of trial that's being proposed, or adding people to the claim because they haven't been originally put into it, all kinds of motions for those purposes. Once all the preliminary stuff is done, you move to discovery, right? So, and after discovery can be either of the person, you know, so you go to a small room across a table. It's not a courtroom. It's usually an office with a court reporter there. And you can ask the other party all the questions you want regarding the claim, and they in turn can ask you all the questions they want. Likewise, this is what's called discovery of documents, which means if you're relying upon any documentary evidence to pursue in your claim, then you have to give it to the other party so they can examine it, and then they can discover you on the contents of those documents. You know, when was it signed? How was it signed? I don't agree that it was even signed at all, those kind of things. And then after you have discovery, you have the trial, right? And that's the trial again with a judge and jury or just a judge alone, right? So that's the court process. So the rest of the class is about the structure of the court, and this is going to take tops 20, 25 minutes, and then we're going to be done. So I will get you out of here before 9. Okay, so the structure of the court basically was established by originally the British North America Act, now known as the Constitution Act of 1867. And there's 2 sections of that act that divide the powers between what became the new country of Canada in 1867. Remember, it didn't exist prior to then. And what was then the 4 provinces of New Brunswick, Nova Scotia, Upper Canada, which was Ontario, Lower Canada was Quebec, those 4. And then they became the provinces, and then obviously it expanded. So we have 10 provinces and 3 territories. But in 1867, it was those 4. And what the Fathers of Confederation did in Charlottetown, Prince Edward Island in 1864 was they met and said, okay, you know, here are the things that this new government of Canada is going to be responsible for as in enacting laws and having jurisdiction over. And here are the things that we're going to retain as provinces. And so Section 91 of the BNA Act, to become the Constitution Act, has a list of all the things that the federal government has authority over, which includes things like fisheries and oceans and telegraphs and criminal law, for instance, and all Indians and lands reserved to Indians. So those are all federal powers. And then the provinces under Section 92 kept things local or private to them. So things like language rights and culture, you know, things that are kind of more of a more private local nature, they stayed with the provinces. So that's what the Constitution Act does, right? And as a part of that, also, it set out who's going to establish courts. So the administration of justice was established as a provincial power. So the provinces are responsible to establish small claims courts, provincial courts, and superior courts, right? And this is important to remember, because even though federal matters are heard in superior courts, the obligation to create the courts themselves is a provincial matter. So if you go downtown to 476 Queen Street, I believe that's the address where we have the courthouse, that's built by the province of Ontario, and it's staffed by provincial employees. And for the most part, the crown attorneys that are in there doing criminal matters are employees of the provincial government. So that was established back in 1867, and it's obviously still the case. It did, however, give the federal government powers to establish courts that were purely of a federal nature. So these include fundamentally 2 courts, the Federal Court of Canada and the Supreme Court of Canada. So the Federal Court of Canada, which used to be called the Exchequer Court, that's the Old English term, it is a court that's dedicated solely for the purpose of suing the federal government. So if your claim is just against the government, then you're going to go to the federal court. The federal court, to a great degree, has been where Indigenous peoples have taken their claims against the federal government, because, again, the federal government is responsible for the Indian Act of 1876, okay? So a lot of Indigenous law has come out of the federal court, and it's developed quite a strong bench, as in justices who sit in the federal court dealing with Indigenous issues, all right? But there's other things, aviation law, you know, that kind of thing will also go to the federal court because it's a federal matter. And then, of course, the Supreme Court, it sits as the highest appellate body we have for all laws across the country. So that's why the federal government has authority over it, all right? So let's go back down to the bottom of the ladder. So small claims courts. So small claims courts, you have it in each province, are established to determine private matters. So again, nothing criminal. So contracts and torts and property issues, right? But they don't have a jurisdiction to hear matters of anything more than $25,000 in value, right? When I first started practicing law a long time ago, the jurisdiction of the small claims court was $1,000, right? And then it went up to $2,000 and then $10,000 and $25,000. So if you're suing somebody and your claim is up to $25,000, then you go to small claims court. And that's a good thing because you don't need a lawyer to go to small claims court. It's designed to be done without lawyers, and you can get the matter heard relatively quickly. And it's mostly online these days, except with any trials that may take place. If you have a claim that's maybe $30,000 or $35,000, but you still want to take advantage of the small claims court, you just have to knock off the top of your claim and bring it down to $25,000, and you can still go to small claims. All right. There's talk, and this has been around for now 5 or 6 years, of increasing that jurisdiction from $25,000 to $50,000. That's a function of inflation, really. I mean, it just makes the small claims court more accessible to anybody who wants to have a matter determined there, again, without hiring a lawyer. The counter punch to that prospect, however, is that once you get up to claims in the $50,000 range, that's a lot of money for most people. Not that 25 isn't, but 50 really is, right? So if you have a claim for $50,000, small claims court, you're going to want to start thinking about hiring a lawyer or a paralegal. Ontario has paralegals now, and they do small claims court work. So in either case, when you get up to the higher numbers, if that's where the small claims court ends up going, you're probably going to want to have help. Although most of you could probably all do it on your own anyway, after you get your degree in law and justice, I'm sure you're going to be qualified for it. Okay, so that's small claims court. We also have provincial courts basically set up in each province. So the provinces in the province of Ontario has a provincial court for criminal matters and one for family matters, right? So for criminal matters, it deals with bail and it deals with very low level, usually summary conviction offenses. So summary conviction offenses, for those you don't know, are the least serious kind of criminal offenses. They're the equivalent of misdemeanors. That's an American term, but probably one that you're more familiar with. Whereas if you're in a criminal matter and and it's not a summary conviction matter, it's going to be what's called an indictable matter, which is the same thing as a felony in the US. So I assume that you guys see more American movies dealing with crime matters than you do Canadian. So that's what it is. And family matters, the same thing, the less serious family matters. So it does deal with custody of children, which obviously is still a very serious issue. And it does deal with support for wives and children. And it's a more expeditious court to go to. But, if you want to go and deal with things like divorce or where property is an issue, you have to go to a superior court. So you can't go to provincial court. Judges are appointed by the province to sit on the Ontario Court of Justice, provincial or criminal or family or criminal. So you will actually get a call. You have to apply as a process for it. You have to have been a lawyer for at least 10 years to apply. But you will actually get a call from the Attorney General of Ontario for this particular position. So you'll get a call, after you've had dinner, and they'll ask you if you want to sit. And chances are you really do, because you had to apply for this job in the first place to even be considered. So it's not much of a mystery about whether you're going to accept the proposition or not. All right. Again, in criminal matters, it's less serious offenses and preliminary inquiries. It also deals with, that should be the YCGA. So youth court is a provincial matter basically, and provincial offenses court, which deals like municipal infractions, speeding, highway traffic offenses. All of those are going to be dealt with in the provincial court criminal division. All right. Again, all provinces have superior courts of justice. We've talked about this already. So in Ontario, the Superior Court of Ontario, Queen's Bench, Manitoba, Saskatchewan, what have you. Judges for the superior courts are in fact appointed by the federal government. Okay, so if you're going to be appointed to a judge, again, you have to put, usually there's not a formal application for this like the provincial court, but you make overtures to people that you think have political clout, let's say, for these kind of positions. And if you're going to be appointed as a Superior Court Justice, you will get a call from the Federal Minister of Justice. So the current Federal Minister of Justice is David Lametti. So Lametti will actually call you, right, and ask if you want to sit as a Superior Court Justice. Since you've pretty much already indicated that you're open for that prospect, it's highly, highly unlikely that you won't take that job on. And again, Superior Court Justice deal with serious matters and include things like divorces, property division, income tax matters, immigration matters, and what have you. So certainly above the level of provincial courts. Okay, so let's talk about the Supreme Court of Canada, established in 1875. So it wasn't even created when Canada became a country in 1867. It wasn't until 8 years later that we created the Supreme Court of Canada. And up until 1949, right, it wasn't even the highest court of appeal in Canada. Up until that year, the highest court of appeal was what's called the Judicial Committee of the Privy Council, sitting in London. So you were talking about 80 years after Confederation. If you were unhappy with a trial and then you appeal it to a court of appeal in the province, the Ontario Court of Appeal, you're unhappy with that. And if you're unhappy with the Court of Appeal, you appeal it to the Supreme Court of Canada. And then if you're still not happy with the decision of the Supreme Court of Canada, you could still go to London and have it heard by, lords sitting in the Privy Council, right? So that's a significant kind of thing. That just tells you how much connection we've had with the English legal system. There are in fact still a bunch of jurisdictions that still have this in place. So if you're not happy with the Supreme Court of Jamaica in making a decision, or the Supreme Court of Antigua or Barbados or Antigua, you can still go to London and have your matter heard, right? Whereas after 1949 in Canada, you had to go to the Supreme Court of Canada afterwards. And that's only place you can go now, obviously, and since that date. Okay, we're going to watch this short clip on what's called the Persons case. This is really interesting. And the important thing about the Persons case is for you to see the difference in having a matter heard at the Supreme Court of Canada and then going further and having it heard by the Privy Council.
They've been called visionaries, trailblazers, feminists, and Canadian heroes, and they're immortalized here on Parliament Hill. Known as the Famous Five, Emily Murphy, Henrietta Maria-Edwards, Irene Parlby, Louise McKinney, and Nellie McClung changed the Canadian political landscape forever. All five women lived during a time with several discriminatory laws in place. This motivated them to take action. They all passionately believed women should be present at all stages of the legislative process. The majority of Canadian women were allowed to vote for the first time in the 1921 election. They could also run for office. But women were unable to enter the Senate. In 1927, the five women asked the Supreme Court of Canada, does the word person of the BNA Act include female persons? After 5 weeks of debate, the Supreme Court decided that the word person did not include women. The five women were shocked by the decision, but were determined. They convinced the Government of Canada to appeal to the Privy Council in England, Canada's highest court of the time. On October 18, 1929, Lord Sankey, the Chancellor of the Privy Council, announced the decision. He stated that the exclusion of women from all public offices is a relic of days more barbarous than ours. And to those who would ask why the word person should include females, the obvious answer is, why should it not? It was a historic moment. The Famous Five achieved the right for women to serve in the Senate. They also paved the way for women to participate in other aspects of public life. But what fueled these women into action, and who were they? Emily Murphy led the challenge. Born in Cookstown, Ontario, she was exposed to politics at a very early age. Having grown up in a family full of politicians and lawyers, there's no question that politics ran through her blood. After moving to Alberta, she began working to protect the rights of women and children in rural areas. She spearheaded campaigns for women's property rights. Her work often brought her before the courts, which was unusual for women at the time. In 1916, she was appointed as the first female magistrate in the British Empire. During this time, a lawyer continually challenged her rulings, claiming that she was not legally a person. Henrietta Maria-Edwards became involved in women's causes at an early age. She joined several religious organizations, discovering firsthand the marginalized traditional role of women. In 1875, Henrietta founded the Working Girls Association, later known as the YWCA. Soon after, she launched Working Woman of Canada, the first Canadian magazine for working women. After moving to Saskatchewan, Henrietta discovered her true passion for women's rights. It was there that she became further involved in feminist organizations. She helped establish the National Council of Women and wrote several books on the legal status of women. Louise McKinney grew up in Ottawa. She went on to become a teacher in Ontario and North Dakota, and eventually moved to Claresholm, Alberta. It was here in Claresholm that Louise founded a local chapter of the Women's Christian Temperance Union. She played a leading role in giving Alberta women the right to vote in 1916, and was the first woman sworn into the Alberta legislature, the first woman in any legislature in the British Empire. As an MLA, she worked to initiate social measures for immigrants and widows. The eldest child of a British Army colonel, Irene Parlby was born in England. Her father's profession meant she moved around a lot, having lived in both India and Ireland during her childhood. Irene came to Canada in 1897, settling in Aelix, Alberta. She quickly became an advocate for rural women and children. In 1921, she was elected to the Alberta legislature, becoming the first female cabinet minister in Alberta and the second one in the British Empire. Later, she was selected to represent Canada at the League of Nations in Geneva. Nellie McClung, the last of the famous five, was born in Chatsworth, Ontario. Soon after, she moved to Manitoba, where she would see her start as a social activist. As a novelist, a legislator, and suffragette, her influence was felt across the prairies. Nellie McClung has been considered one of the most important leaders of Canada's feminist movement. She helped Manitoba women win the right to vote in 1914, and was instrumental in the majority of Canadian women winning the right to vote in 1918. 5 months after the Persons case was delivered, a woman was appointed to the Senate. She was not one of the famous five. On February 15, 1930, Corinne Wilson entered the upper chamber for the first time. She was known for her dedication, intelligence, and deep compassion. Although her appointment was applauded across Canada, many in the West questioned why Emily Murphy had not been chosen. Despite their pivotal role in obtaining the right of women to sit in the Canadian Senate, none of the famous five were appointed to the upper chamber. More than 80 years later, the famous five continue to inspire Canadians. They're remembered as five fearless women who've dedicated themselves to improving everyday life for Canadian women.
Okay, so that's a really, really important case, because not obviously not only for the purposes of having women be admitted to the Senate, but in 1927, when the Supreme Court made that decision, if there wasn't another body to go to, as in the Privy Council in London, then that would have been the law for an extended period of time. As a matter of fact, the only way to change the law, right, because it wouldn't get back to the Supreme Court of Canada anytime soon, because there's an incredible process we're just going to talk about now. It would have required an amendment to the British North America Act, and that itself was an incredibly onerous thing, because remember, the British North America Act, although it created Canada, was a British statute. So in order to amend it, they would have, the Canadian Parliament, or whoever was seeking to change the law, would have had to go back to Britain and amend the BNA Act. So incredibly complicated. So it's a really, really good example of, in this particular case, that it was a good thing that the Supreme Court of Canada was not the last arbitrator of the law. Okay, so all we're going to do now is I'm just going to give you a quick overview of the Supreme Court and what it deals with. So the Supreme Court of Canada deals with appeals from the Federal Court of Appeal and from all provincial courts of appeal. So again, in Ontario, it hears appeals from the Ontario Court of Appeal. There are usually 600 to 700 applications filed every year. That's a pretty standard number. And in any 1 year, the court will hear 60 to 75 of them. So approximately 1 out of 10 appeals will actually be heard. In order for a case to, in fact, be heard by the Supreme Court, it has to have a legal issue of national importance, right? So even if on the face of it, the decision at a lower court of appeal was absolutely wrong, and sometimes even a miscarriage of justice, the Supreme Court won't hear it if it doesn't have application across the country, right? So that's why it limits its decisions, because that's its purpose, is to make law across Canada. So prior to 1982, most of the Supreme Court's decisions dealt with the jurisdiction between the provinces and the federal government, sections 91 and 92 of the British North America Act, right? So there was always competition between the two levels of government as to who had authority over what, almost always that authority dealing with how to make money. So in the 20s and 30s, a lot of the jurisprudence in the Supreme Court dealt with a fight between the provinces and the federal government over taxation of cigarettes, right? Money taxing cigarettes was a big money maker. It still is to some degree, but back then it was a great, humongous money maker. And both levels of government indicated that they have the jurisdiction to collect tax on it. So that's the kind of thing that the Supreme Court heard, for its first, from 1875 to 1982, however many years that is. From 1982 forward, however, the vast majority of cases it deals with are for criminal law matters, right? Because of the charter. So that, as a function of the charter being a new rights instrument in 1982, there was a ton of litigation, obviously, that was going to come before it. And because the charter applies across the country, as does the Criminal Code of Canada, then, almost every charter issue that made it all the way to the Supreme Court was of national importance and in fact would be heard. The Supreme Court also dealt with, apart from the division of powers in the charter, it's had a lot of jurisdiction on Indigenous rights. It's probably the third most popular type of case that's gone there, because again, Indigenous rights apply across the country, whether you're a member of a First Nation, there's 630 or so for reserves for First Nations, or you're Métis or Inuit, and what have you. So, those are the kind of cases that are heard. As a rule, for most of the last 10 to 15 years, when a matter is heard before the Supreme Court, all 9 judges sit on it, okay, because that's how many members there are. Sometimes, not often, 7 judges will sit. The court can also hear only 5, but that virtually never happens anymore. So it's almost always 9. The process to start an appeal is what you do is you prepare what's called an application for leave to appeal. The word leave means permission. So application for permission to have the appeal heard. And that application sets out your entire case. So you prepare the application for leave as if you were actually arguing the appeal, because in real terms you actually are. You have to convince the court that your case is worthy of an actual full appeal. Applications for leave are in writing, and they're heard by 3 judges of the court behind closed doors. It didn't used to be that way up until about 1990. When you had an application for leave, you actually went to Ottawa and argued that leave application. I actually did that in 1983, so that's historical, but I did that, and that's when leaves were actually argued before the court. But now it's behind closed doors. You never know who hears it, who is actually reading your leave application. And again, 9 out of 10 applications for leave are dismissed, and no reasons are ever given. So notwithstanding the fact that you've spent hundreds of hours preparing your application for leave, which sets out your entire appeal, if it's dismissed on the leave application itself, you never know why. So that's kind of frustrating, but that's just the way it is. When an appeal is actually heard, it doesn't have to have a unanimous decision by the judges that are hearing it. It only has to be a majority. So out of 9, at least 5 have to agree, and then the other 4 can be in dissent. And judges who are in dissent, they can write reasons for why they're dissenting, just like those who are in the majority write their reasons why they agree for it to succeed, and those are published. So you'll always know the outcome of all the decision makers if you actually have an appeal heard, basically. Decision making at the Supreme Court has changed over time. It's moved from what's called a strict interpretation of the law to a more creative approach dealing with the change of social conditions. So it's gone from being a strict, what does the law actually say, to basically, what does the law intend to do? What does it really, what should it do? And that's a function of the charter to a great degree, right? So that's called judicial activism, and it broadly applies and preserves individual rights. It's actually called, it's a tree. It's looked at as a tree that grows, and as the law is the trunk, and as social conditions change, it branches out in different ways, right? So that's the metaphor for it. It can also act, the Supreme Court can also act as an advisory body on constitutional issues sent to it by the federal government. Those are called reference cases. They very rarely happen, but if there's a really, really important issue to be heard, then the federal government will send it to the court for an interpretation. The last one that was sent to the court was on the right of Quebec to separate from Canada. You guys are all too young to be part of that political environment that that I lived through, certainly in the 60s and 70s. Back then, this is now 50 years ago, there was a very, very strong movement to have Quebec separate from Canada, right? And it involved the creation of the FLQ, the Fédération de Libération de Québec, and which was a terrorist organization, to separate basically. And what the federal government said is, if Quebec wants to separate, if it has a referendum to do so, how many people in Quebec have to agree to separate before it has the legal authority to do so, not just the moral authority, but the legal authority. And the Supreme Court came back and said 50% plus one. So just a bare majority was required, although in the wordings of the judgment, it basically said, but it really should be more than that. There should be more of a moral and ethical persuasion, that is just more than a bare majority, but the number is 50 plus one, all right? Jurisdictions of courts are incredibly important. It deals with territory and subject matter. So when you bring an action for any kind of relief, right, you have to make sure it's in the right territorial jurisdiction, Ontario, Manitoba, what have you. And the subject matter has to be within the jurisdiction of the court. So again, a divorce has to be in Superior Court, whereas small claims can deal with small tort matters. Okay, that's important. So territorial is what law applies. So where was a contract entered into? Now we're going to start talking a little bit about sports, and this is the last couple of slides, and we'll move much more into sports next week and going forward. But in sports context, if there's a claim that goes to court, where was the sport played? Is that going to determine what court you go to, right? Or if you've entered into a management contract with a manager or a team, is where you entered in that contract where the court or a case should take place, or would it be where there was a breach of that contract, perhaps in another country? If you're in if you're in a league, the NHL, NBA, Major League Baseball, anything that crosses borders. And again, and we'll talk a lot about this more later on, the home of the athlete is important, right? So especially for doping. So if an athlete is accused of doping at the Olympics, right? Is it the law in the country coming up Tokyo? Is it the law in Japan that applies? Or is it Canadian law back home that applies? And we'll talk about that in a lot more detail in the class on doping. Or if a sport is played and there's an injury, do you sue if the team or the coach or somebody was negligent giving rise to a player being injured? Does the player sue the team or the coach, where the team, if it's the Toronto Blue Jays in Toronto, or if the injury was in Atlanta where they're playing tonight, if the player was injured in Atlanta tonight, would they sue in Georgia, right? These are all really important questions. You have to know, the law as to know how to proceed. And the subject matter is incredibly important. So an example is doping. So for those of you who have your textbook, on page 5, there's a really good graph on the application of multiple jurisdictions in a doping matter. So I'm not going to go through it in detail, but if you look at it, it gives you a schematic as to where would you actually sue based upon a doping matter relating to, where the games are played, where you come from, where are the international rules relative to the game established. All those kind of things, again, are incredibly important to know, and you'll learn all about that as we go through the course. All right, guys, it's like 2 minutes to 9. I made it, right? It's not 9 o'clock. So that's it for tonight. There's a long lecture. I apologize. I'll break up the lectures, hopefully, with other things going forward. And next week, you will have both breakout questions and videos to take a look at tomorrow or Friday. And so the videos we'll use for discussion purposes at the beginning of class, and the breakout questions, I'll break you into groups after the lecture for the purposes of getting together, coming up with a response to the question, and presenting it to the class. All right, any questions, anybody? Okay, I appreciate the participation tonight. You know, it's, you know, for a lecture like this, the participation was great. And so those who participated, I kept track of you, and I will mark you a mark accordingly. After most classes, I send out a Google form that basically confirms your participation in the class and your level of participation, you know, as in answering or asking questions. But having said that, thank you very much, guys. Next Monday night is negligence and liability, and it's really, really interesting. So hopefully you enjoy it. Thank you, guys, and we'll see you next Monday.